So, hi everyone, myself Advocate Vaishali, as Malvika introduced me, and this is our second lecture on the topic of moot court. इसके पहले lecture में we had gone through about how to prepare for a moot court, the arguments, the research, and today we'll be dealing with the most essential part, memorial drafting. So, with a little gist of what a memorial is. Memorial is as good as a, we can say, petition to the court. But the only difference is that petition जो हम कोर्ट में इस्तेमाल करते हैं, it is very different to how a memorial is drafted because the two never have any similarity between each other. Memorial में we plan to give a gist of what we are arguing before the court, whereas in a petition obviously we just write the facts of the case and we plead the relief. हमारे मेमोरियल और हमारी पिटिशंस में यही फर्क पड़ता है दैट इन द मेमोरियल वी प्लीड द लॉ, वी आर्ग्यू अपॉन द फैक्ट्स, वी आर्ग्यू अपॉन द केस लॉज, and then we say that this is the relief which we pray from the court. So in order to explain drafting of a memorial in a more better way, I had shared a moot problem. So based on the moot problem today, we'll be discussing about how to draft a memorial. In fact, even how to draft the legal acumen तरीके से, and साथ ही साथ how to understand how to frame our storyline. So going with a little gist of the moot problem, as you guys know that mostly moot cases जो होते हैं they are based on constitutional law, especially in regards to Article 32 to 26 of the Indian Constitution. However, it was my dearest wish to take a moot problem on a little subtle topic. So that's why I've chosen check bounce cases, Section 138 of the Negotiable Instruments Act, so that we can concise it within our today's session. So, but going one step ahead, mostly moot courts में आपको जो moot problems मिलती हैं, they are not as simple as the moot problem which I've given you guys today. It is just one page long. The moot problems which you get in your moot courts are usually 10 page long, 20 pages long. There's a reason for that. उनका मुद्दा केवल एक पेज जितना ही होता है. But it's a very smart way where you write unnecessary facts just to distract your participant so that it is the participant's job now to find the actual problem and fight it out. So before you start drafting the memorial, the most important part is to actually read the moot problem. You have to read the moot problem and you have to figure out कि कौन से facts आपके काम आएंगे and कौन से facts पे आपको debate करना पड़ेगा. Once you are clear out on what facts you have to debate upon, that is where your research starts, first finding out the case laws so that you can change the facts which are going against you to in your favor. And this is where your research starts. So once you are done with the research, with the studying of the moot problem, you have to draft the memorial. Now moving on with the drafting of the memorial, I'll share my screen. I have created a draft memorial. It does not have everything that one wants in the memorial, but it'll give you a gist about memorial दिखता कैसा है. And for everyone who has joined in, it is my humble request that please ask your questions, because for me also as a law student, it was a tough thing to understand how memorial is drafted. So if you have any doubts, Bina Hichkichai, just ask it out today. We'll clear it. As well as to the point that memorial has a lot of blank spaces. The reason is that it varies for every case to case. So if you guys are making notes, आप screenshot ले लीजिए screen का, and then you can very well go ahead by copying this. Doesn't matter. So memorial starts with the cover page. हमारा जो cover page है, it varies for the petitioner and for the respondent. सो मूविंग ऑन, हमारा मेमोरियल का फ्रंट पेज. नाउ हमारा मेमोरियल का जो फ्रंट पेज होता है, इट वेरीज फॉर द पेटिशनर एज वेल एज फॉर द रिस्पोंडेंट. पेटिशनर के केस में द फ्रंट पेज हैज टू बी ऑफ द ब्लू कलर एंड द रिस्पोंडेंट्स मेमोरियल हैज टू बी इन द रेड कलर. सो प्लीज टेक अ नोट ऑफ इट. आपके कलर्स बहुत इंपॉर्टेंट है बिकॉज इस पे मार्क्स भी होते हैं एंड दे डिडक्ट मार्क्स इफ यू डू नॉट हैव अ कलर्ड फ्रंट पेज. They do not practice this in the actual courts, so you need not worry when it comes to court filings that you have to get a blue colored page or a red colored page. Now one more idea I have over this, it's a quite creative one. This idea which I have used is I have created a box. ये एक table का एक column है. In that I have filled the color, and then color fill करने की वजह से when I'll take a color print of this page, as you can see, I'll go to the table design. So I've made a table box over here and I've shaded it using the shading box. तो अपने आप जब मैं इसका प्रिंट लूंगी तो इसका ब्लू कलर दिख जाएगा. So this is one way of making your page. Second way is that you actually buy an A4 size blue color sheet, then you take a printout over it, because I've seen many of my fellow law students who are very troubled how to take a printout on a blue colored page. Starting on with the first page, what to write in it. हमारे कोर्ट केसेस में भी एंड मेमोरियल पेटिशंस में भी First thing which we write is the cause title. As you guys can see, this part where it starts from before the Honorable Judicial Magistrate till the ending is called the cause title of the case. It defines कि आप कौन है, अर्थात कंप्लेनेंट कौन है, एंड किसके खिलाफ आप केस कर रहे हैं, अक्यूज्ड कौन है, आप किस कोर्ट के सामने आए हैं. So the first sentence states you are before whom. So in the present case, since it's a 138 proceeding, तो वो हमेशा जेएमएफसी जजेस के सामने जाती है. सो हेंस वी आर राइटिंग बिफोर द ऑनरेबल जुडिशियल मजिस्ट्रेट फर्स्ट क्लास. If this was before the Honorable Supreme Court, then we have written before the Honorable Supreme Court of India at New Delhi. Then we move on to the case number. And usually, it is a practice of many law students where they mention under it the provision under which they are filing it. So even we may do that under section 138 of the Negotiable Instruments Act. For now, I'm just writing the short form, but it is my humble request to everyone that refrain from mentioning short forms in the cause title. It does not look neat. Moving on to defining who is the complainant. In our case, it is Digital Electronics Limited. And then who is the accused? Messrs Techno Innovators Private Limited. उसके बाद we have put a dash. This dash which I have put, I know many students will be thinking कि ये क्या है. So it is also a table design only. You can put this, or there is a very simple way. I'll show you the simple way also, because these are all drafting techniques. So keeping them handy is also quite necessary for us law students. So the simple way is that आप shift की दबा के जो underscore है, you'll stretch it to the very end, and then that's when you'll push the enter button, and then you get a dash also itself. Otherwise, the other way is that you go and add a shape. Then you have to write memorial for the petitioner, as well as you can mention over here also that your complaint is under section 138, read with section 141 of the Negotiable Instrument Act. Now this becomes your cover page. Post your cover page is the table of contents. टेबल ऑफ कंटेंट्स गिव्स अ जिस्ट कि आपने अपने मेमोरियल में क्या क्या डाला है. एंड ऑल दो स्टूडेंट्स हु आर मेकिंग नोट्स, प्लीज टेक अ स्क्रीनशॉट ऑफ दिस पेज. You'll have to mention by default all these contents in your memorial. इनफैक्ट कुछ कॉम्पिटिशन्स जो हैं वो इसके अलावा भी बहुत सारी चीज़ें बोलते हैं डालने के लिए. सो इफ योर कॉम्पिटिशन इज स्पेसिफिक अबाउट एडिंग फ्यू मोर थिंग्स, you have to mention it over here. Like for example, I remember going to a competition where they had asked to put pages for court proceedings or court records, the way we put it before the Honorable High Court's petitions. We put 3 to 4 blank pages so that the court, if they have to mention any remarks, they may mention on the blank pages. So you have to just mention it in your index as well. So first thing being list of abbreviation, then index of authorities. List of abbreviations हम सब जानते हैं. It is the short forms which we have used in our memorial. So you have to specify those short forms, and obviously there's another way to do that as well. I'll proceed ahead with it. Then index of authorities, अर्थात आपने कौन सी judgment cite की है उनके citation codes के साथ. Then statement of jurisdiction, statement of facts, statement of issues. Statement of issues अर्थात single sentences, that is what are the issues before the honorable court. Summary of arguments, and then arguments advanced with each specific issue given, and then the prayer. This is a gist of what a simple table of contents has to look like. Now, moving on to the list of abbreviations. So, honestly, in my view, list of abbreviations is a page which is not required at all. I know many people won't agree with me, but the point is that list of abbreviations is something which comes to your rescue when you have used such an abbreviation which is not known to the common world. Now, obviously, you can see that I have mentioned abbreviations over here which are known almost by everyone, but these things come into picture when you have the names of the petitioners or of the respondent which are so lethargic. Like for example, if the name of the petitioner is ABCD Exports Private India Limited, so that's a very long name. आप बार बार वही नाम लिखेंगे, then your entire memorial will go ahead of 35 pages. So that's where the abbreviation part comes into picture, that you can create an abbreviation for it. Other than that, in my view, this thing has no other relevance, but then also we have to create a page for it. Moving on to the index of authorities. Now, this is a very important page because over here you're mentioning all the judgments which you are relying in support of your arguments. And honestly, students, I have seen this, that the competitors, the judges, they do see the length of your index of authorities, as in आपने कितने ज़्यादा judgment cite किए हैं. So it is always a good thing to have a plenty number of judgments in your hand. हालांकि इट इज योर डिस्क्रिशन कि आपको वो सब जजमेंट्स पे आर्ग्यू करना है 10 मिनट में या नहीं. आई हैड टेकन दिस पॉइंट इन माय फर्स्ट लेक्चर आल्सो. आई विल से इट राइट नाउ आल्सो कि आपके पास अगर 20 पॉइंट्स है and you have only 10 minutes to say those 20 points, it is now your discretion to decide कि आपके जज को उस टाइम कन्विंस करने के लिए आपको क्या क्या बोलना पड़ेगा. Because if presently, as you can see, there were 19 judgments which I had used in this memorial. Now, if I go on to read 19 judgments before the judge, 10 minutes is not the appropriate time. So now it is your decision to see कि कौन सी judgment on point है, कौन सी judgment landmark है इनमें से, या फिर कौन सी judgment को higher bench ने assent दिया है. And then you read the appropriate judgment before the honorable court, before the judges. And then during the rebuttal, if you realize that, okay, there's one more judgment which can come in my favor, that's when you open the cards. There is not a necessity कि आप 20 के 20 judgments उस टाइम 10 मिनट में बोले. हालांकि उनका मेमोरियल में होना बहुत जरूरी है. So just ensure that all the judgments which you can find on the internet, on the researchers, you mention them in your judgment cited list. And then coming to the point of citation code, I have seen many law students who miss out on this point because this is where your marks come into picture. All the judgments which are reported by the Honorable High Court, Supreme Court, tribunals, they all bear a citation code. अभी citation code क्या है? Citation code is the way a law reporter recognizes a particular judgment. अर्थात अगर हम एग्जाम्पल लेते हैं कि आज ऑनरेबल सुप्रीम कोर्ट ने एक जजमेंट दिया ABC वर्सेस XYZ, तो उस जजमेंट को AIR, SCC, मानुपात्रा या फिर और कोई लॉ रिपोर्टर जब रिपोर्ट करेगा अपनी लॉ जर्नल्स में, तो वो अपनी लॉ जर्नल के उस पेज के कोड को उस साइटेशन कोड मानेंगे. So whenever we say any judgment, we refer to a law reporter which had cited that judgment or which had reported that judgment. And that code which we are reading is the citation code of the judgment. So हम citation codes को कैसे understand करेंगे? The first thing which we see, 1959, first judgment, Kerala Bill Education, Kerala Education Bill 1957. ये जो 1959 है, this is the year the judgment was reported. SCR, it is the short form for Supreme Court Recorder. That is, इससे हम एक अनुमान लगा लेंगे कि judgment Supreme Court की है. And then 995 is the page number. Now, obviously, the citation codes are not the same for all the law reporters. Like, for example, the very next judgment which we see, SP Mittal versus Union of India, this is of AIR 1983 SC1. तो इसमें citation code अलग है. This is where you need to read through a lot of law reporters to understand that how differently they cite a judgment. So over here, the first we see is the acronym AIR, All India Reporter. Then we see the year when it was reported, 1983. Then we have SC, that means the judgment was of Honorable Supreme Court. And then we have the page number 1. So actually, the reason why I'm stressing more on citation codes was because one of my competitions I had gone, we were in the semi-final rounds. And to the opposite party, this question was asked by the judge that, can you explain me the citation code? And that is when the opponents, they were taken aback that who asked to explain the citation code. And honestly, they were not able to explain कि citation code में लिखा क्या है, AIR का क्या अर्थ है, 1983 क्या है, SC अर्थात क्या, and उसके आगे जो नंबर है उसका क्या अर्थ है. And then the judge shouted on them that you don't even know what a citation code is and you are referring to a judgment. So we all face these kind of embarrassments during the moot court, but that is when we also understand that how trivial these small details are. So moving on, these are the judgments which we had referred. And then there is a new fashion to mention the list of citations. We also mention the legislations referred. So in the present case, we are referring to Constitution of India. It is something which is applicable to all the cases. Then Negotiable Instrument Act. Now, particular to what moot problem you are dealing with, you have to mention all the bare acts. In fact, if you are referring to any legislation passed by the United Nations, then you have to mention that also. And obviously, there are few cases जहाँ पे हम foreign legislations को भी refer करते हैं, just to draw a comparison also. तो आप foreign legislations भी mention कीजिए, because it strengthens your memorial. When you submit this memorial for adjudication, for judgments, for marking, तो आपके marks को वो refer बढ़ाएंगे, because they'll see that you have gone beyond the four walls, and that is where you get a brownie point. Now moving on, statement of jurisdiction. I have not specifically used the words which we mostly write in the statement of jurisdiction for a simple reason that it will be my humble request to all the participants कि आप अपने आप draft करिएगा ये statement of jurisdiction. I'll duly explain you how a statement of jurisdiction is drafted. So in order to begin with that, we need to understand the statement of jurisdiction होता क्या है. It is the particular कि आप जिस कोर्ट के सामने इस वक्त अपनी पिटिशन फाइल कर रहे हैं या फिर अपना मेमोरियल फाइल कर रहे हैं, उस कोर्ट के पास आप किस पावर के अंदर आ रहे हैं, अर्थात किस प्रोविजन के अंतर्गत, विच प्रोविजन एम्पावर्स यू टू गो टू दिस ऑनरेबल कोर्ट एंड आस्क फॉर अ रिलीफ. That is what has to be written in the statement of jurisdiction. What provision are you invoking to get a relief from the present honorable court? So what does this has to mention? First thing, which court have we approached? So in the present moot problem, we have approached the JMFC court, Honorable Judicial Magistrate First Class. So you have to mention that the complainant hereby humbly states that the present complaint has been filed before the Honorable Judicial Magistrate First Class at New Delhi. Now what provision? So over here you have to mention that which provision empowers you to file the present petition or empowers you to file the present complaint. नाउ मोस्टली अगर हम मूड प्रॉब्लम्स की तरफ प्रकाशित करें तो दे आर यूजुअली अंडर द कॉन्स्टिट्यूशन ऑफ इंडिया under article 32 226. So you have to mention that we have invoked the powers under article 32 of the constitution of India. In the present case, we are going to say that we have approached the honorable court under section 138 of the negotiable instruments act, read with section 141. Then we have to mention for what reasons हम क्यों आए हैं कोर्ट के पास. So then you have to mention that the reason why we have approached the honorable court is because we claim relief of double the check amount जो हमारे provision के अंदर relief है. Otherwise, if you have gone to the honorable Supreme Court and you want to get a writ of mandamus, then to get a writ of mandamus, we have approached the honorable Supreme Court. And any other alternate. Yes, then whether is it exhausted? ये बड़ा important point है. Because mostly जब हम moot courts में constitutional law पे debate करते हैं, and we have approached the apex court, honorable supreme court, तो हमसे जजेस एक ही सवाल पूछते हैं कि हमारे पास आने से पहले आप क्या कर रहे थे. Have you approached the honorable high court? Is there any other alternate way to solve this issue? And then you can come to the supreme court, and then you have to answer to them that, sir, I had filed a writ petition before the honorable high court, it was dismissed, that's why I approached you under appellate jurisdiction. And if not approached you under the appellate jurisdiction, I filed an SLP, sorry, I filed it directly to the honorable supreme court. Then what is the reason for that? Because there has to be some important or something so crucial which made me come before the honorable supreme court, तो आपको वो भी बताना पड़ेगा. And then you have to convince the judges that there is a reason why you are there before the honorable court. So statement of jurisdiction in short simply specifies कि आपका पर्पस क्या है कोर्ट के सामने आने का, and if that purpose is so important that the honorable court will have to invoke its jurisdiction to solve it out in this petition. And once you convince them for statement of jurisdiction, I can give it to you in writing that your judges will now be more convinced to hear you. Like for example, I'll give you one more example. I had once appeared in this moot court. It was based on the act which had recently come for pregnancies caused by IVF, sorry, by pregnancies which are done by the pregnancies which are done usually by mothers who are not genetically related to the child, like they bear the children for the actual genetical parents. So उस केस में हमारे पास दो जजमेंट्स थी. एक्चुअली उस केस के पेक्यूलर फैक्ट्स भी ऐसे थे कि उस केस में द मदर शी वाज अ ट्रांसजेंडर. So उस टाइम पे कोर्ट ने हमसे सवाल पूछा that are there any other ways which we could have exhausted, any other relief which we could have exhausted before directly coming to the Supreme Court. So that's when I had an answer that मैम हमारे इस केस में एक सवाल ये भी उठा है कि क्या हमारी petitioner, that is the mother, is she a woman or not, or is even her marriage valid or not. तो इस केस में दो ये है conflicting views है. One view is of the Honorable Punjab High Court, which is an actual judgment, which says that even if a transgender woman marries a man, it is a valid marriage because she is a woman now. Whereas in facts of our case, the Honorable Bombay High Court has said that no, it is not a valid marriage. So hence there are two conflicting views of High Courts, and hence Honorable Supreme Court is required to clear this view. So over here, when you convince the judge that yes, आपका होना इस केस में जरूरी है, she hears you more. She is in fact interested to hear you more. सो मूविंग ऑन टू द स्टेटमेंट ऑफ फैक्ट्स. हमारे स्टेटमेंट ऑफ फैक्ट्स का प्रॉपरली डिफाइंड होना बेहद जरूरी है हमारे केस के लिए, बिकॉज व्हेन द स्टेटमेंट ऑफ फैक्ट्स आर क्लियरली रिटन डाउन, even your mind is clear that how or which trajectory you want to follow to get your case solved, to argue your case better. So it is my way where I first define who is the petitioner. So for now, I have taken the liberty to merely mention the name because our mood problem is small. But it will be a humble request to all the participants कि आप petitioners को पहले बताइए, introduce your petitioners कि वो क्या काम करते हैं, कौन है, कहाँ रहते हैं, उनके साथ क्या ऐसा हुआ कि वो आज कोर्ट में आए. देन अबाउट द रिस्पॉन्डेंट्स कौन है, क्या काम करते हैं, किधर रहते हैं, and then come to the facts of the case, that is the pleadings which lead to the cause of action of the case. कैसे क्या हो गया ऐसा कि आपको आज कोर्ट के पास आना पड़ा. एंड ऑल्सो वन पॉइंट टू रिमेंबर, आपके पूरे मेमोरियल को बनाते वक्त आपका हर एक पॉइंट नंबर्ड होना चाहिए. प्लीज इंश्योर दैट यू आर फॉलोइंग प्रॉपर ड्राफ्टिंग एटिकेट्स. जैसे आप अभी देख सकते हैं कि इस पेज में जस्टिफाइड अलाइनमेंट है. इट इज अ कंपल्शन फॉर ड्राफ्टिंग अ मेमोरियल. Then the font size is given to you by the parties, by the college who is organizing for the competition. The font style is also prescribed by them mostly. If not, then Times New Roman is the only choice which we have as law students. And then you have to ensure that your drafting looks neat. I've seen many students who draft pretty good memorials, but then they clutter it up so much कि उसको पढ़ने की इच्छा ही नहीं बचती है, because your mind can only read things when it is set up in a neat way. If it is all cluttered up, उनको इतना ज़्यादा numbering कर दिया गया है, like 1, then subclause 1, then subclause A. This creates a shabby memorial. So it will be my humble request that whenever drafting a memorial, you have to strict to one numbering. 1, 2, 3 है तो 1, 2, 3 ही रहना चाहिए आगे तक. If you want, then sub points can go to 1 subclause A. But higher than that, I would request you to avoid doing that. Now moving on, facts of the case. फैक्ट्स ऑफ द केस यू हैव टू इंश्योर कि आपके मूड प्रॉब्लम में जैसे लिखे हैं आप एज इट इज उनको नहीं लिख रहे हैं. बिकॉज द रीजन इज दैट अगर आप उनको एज इट इज लिख देंगे जैसे वो मूड प्रॉब्लम में है, तो देयर इज नो डिफरेंस ऑफ टेकिंग अ मेमोरियल अहेड विद यू एंड देन मेंशनिंग फैक्ट्स ऑफ द केस. आप सीधा सीधा उन्हें मूड प्रॉब्लम दे सकते थे जजेस को पढ़ने के लिए. सो इट विल बी माई सजेशन कि आपके पास मूड प्रॉब्लम जब आएगा, यू विल सिट डाउन विद द मूड प्रॉब्लम एंड यू विल कंसाइज द फैक्ट्स ऑफ द केस. आप उनको एक समरी फॉर्म में क्रिएट करेंगे एंड देन पैराग्राफ वाइज आप सिर्फ वही फैक्ट्स लिखेंगे जो आपके काम के. बिकॉज एज अ पिटिशनर आई कैन गिव इट टू यू इन राइटिंग इवन एज अ रिस्पॉन्डेंट कि आपके केस के लिए सारे फैक्ट्स काम के हो ही नहीं सकते. There are few facts which favor the petitioners. There are few facts which favor the respondent. So अगर आपको अपना केस बनाना है तो आप अपनी स्टोरी लाइन लिखेंगे which will be the facts of your case. And then you have to mention कि क्या opposite party इस केस में बोलना चाह रही है. Defense is taken by the accused. That's it. And your language has to be such कि जब कोई आपके डिफेंसेस पढ़ेगा या फिर जब भी कोई आपके फैक्ट्स ऑफ द केस पढ़ेगा, आपके फैक्ट्स ऑफ द केस पढ़ के ही इज कन्विंस्ड दैट यू शुड गेट द केस इन योर फेवर. The reason why I'm stating that, because कोर्ट में भी जब हम कोई पिटिशन फाइल करते हैं, प्लेंट फाइल करते हैं या कंप्लेंट फाइल करते हैं, we only get to write the facts of the case, because in actual courts we cannot write the arguments in our petitions. So in those scenarios आप सिर्फ facts of the case लिख के अपने केस को justify कर रहे हैं. So to understand that, the first step to do is start drafting a memorial facts of the case in such a way. It will give you a practice on how to do it in the actual courts. So once you write the defenses by the accused, you directly move on to the statement of issues. Now, statement of issues is nothing but a replication of the statements of the issues which are given in the moot problem. आप उनको A, B, C, D करके mention कर देंगे. And then I believe many competitions they even give you the liberty कि आप अपने मन के issues भी mention कर सकते हैं. So obviously, if you wish to add more issues that which you believe can be debated upon, go ahead, mention those. It will always be a great addition to your memorial. Now, moving on, once the statement of issues has been mentioned, we have to write the summary of arguments. अभी summary of the arguments मैंने जो एक simple form में यहाँ पे लिखा है, like first issue being कि whether the dishonor of the check issued by Techno Innovators Private Limited constitutes an offence under section 138 of the NI Act. So our first statement, summary of petitioner's argument in support, अर्थात पेटिशनर इस इशू के सपोर्ट में बोलना चाहता है that in affirmative that the dishonor of the check issued by constitutes an offense under section 138 of the act. Now after this you have to write a one liner or two liner to justify that why you are saying so. So for example अगर हमें अभी on the spot लिखना होगा कि whether the dishonor of check issued by Techno Innovators Private Limited constitutes an offense under section 138, we can always say that under section 138 of the NI Act, there is a presumption in the favor of the complainant that the check was issued for a legal debt and it is the accused who has to justify to the contrary. So this can pretty well be written over here as a summary of your arguments. Please ensure that you are not putting stories in the summary of arguments. It has to be in a concise form and it has to give a gist of what you are trying to say. तो अगर आपका मेन पॉइंट यही है कि द डेट वाज अ लीगल डेट or the debt is an admitted debt because the accused had written us an email admitting to the debt, तो ये सब आपके वो बोनस पॉइंट या फिर वो इंपॉर्टेंट पॉइंट है जो आपके केस को आपके फेवर में दे रहे हैं. सो यू हैव टू जस्ट मेंशन दैट पॉइंट ओवर हियर. नो नीड टू मेंशन द जजमेंट्स, नो नीड टू मेंशन द प्रोविजंस, जस्ट योर समरी. एंड एक्चुअली द पर्पस ऑफ समरी ऑफ आर्ग्यूमेंट्स is that ये जब जजेस गो थ्रू करेंगे आपके मेमोरियल को बिफोर यू स्टार्ट द आर्ग्यूमेंट्स, दे गेट अ जिस्ट कि आप बोलना क्या चाह रहे हैं. ऑब्वियसली गोइंग इनटू 10 पेजेस ऑफ आर्ग्यूमेंट्स बिकम्स मोर लेथार्जिक. सो ये सोच के ड्राफ्ट कीजिएगा कि ये पढ़ के जजेस अपना माइंड फ्रेम बनाएंगे कि आप कहना क्या चाह रहे हैं. सो यू हैव टू बी वेरी क्लियर and very specific over here. Now, second, in the third issue which I've used a different sentence, summary of petitioner's argument in deniance. So यहाँ पे यू हैव टू एंश्योर कि अगर कोई इशू आपके अगेंस्ट में है तो आप उसको सपोर्ट ना कीजिएगा. यू हैव टू वेरी विविडली राइट दैट यू आर इन डिनायल ऑफ दिस इशू. आई हैव सीन मेनी स्टूडेंट्स वेयर दे गेट कंफ्यूज्ड विद द लैंग्वेज यूज्ड इन द इश्यूज एंड दे एंड अप सपोर्टिंग द इशू which is actually contrary to their case. So, like for example, we'll see the language of this very issue. Whether the defense of delegation of authority and lack of knowledge is a valid defense under section 141 of Negotiable Instruments Act for the individual directors. So as petitioners, we have to say that it is not a valid defense. So we have to ensure that we are denying it. We are denying that no defense that delegation of authority and lack of knowledge is a valid defense is a wrong defense. And then you have to mention our reasons that this defense is wrong because as per section 141, the directors of the company are liable for the company even when the checks are not signed by them. So this is where the summary of arguments end and arguments advanced start. Now arguments advanced is your everything. You have to ensure कि आप अपने arguments advanced को इतना डिटेल में लिख रहे हैं कि भले वो 10 पेज में जाए, बट यू हैव टू एंश्योर कि आप सब पॉइंट्स कवर कर रहे हैं. आपकी जितनी भी जजमेंट्स हैं यू मेंशन देम ओवर हियर एंड देन यू इवन राइट योर ओन व्यूज जस्ट सो दैट यू एंश्योरिंग कि अगर आपके ओरल आर्ग्यूमेंट्स में कुछ मिस हो गया, द जजेस कैन वेरी वेल रीड योर मेमोरियल एंड देन डिड्यूस योर पॉइंट फ्रॉम देयर. इनफैक्ट आई टेल यू वन मोर पॉइंट. हमारे साथ ऐसा कई बार होता है कि हम मेमोरियल्स ड्राफ्ट कर देते हैं एंड देन उसके बाद जस्ट ऑन द लास्ट डे बिफोर आवर आर्ग्यूमेंट्स वी कम अक्रॉस अ न्यू पॉइंट. तो भी होता क्या है, द जज कैन प्रीटी वेल से कि वेयर इज दिस पॉइंट मेंशन इन अ मेमोरियल, हाउ कैन यू आर्ग्यू ऑन दिस व्हेन इट्स नॉट देयर इन द मेमोरियल. सो दैट्स व्हाई गिविंग अ वाइडर एम्बिट टू योर आर्ग्यूमेंट्स कि आप ब्रॉडर पर्सपेक्टिव में लिखें एंड देन यू कैन ऑलवेज से कि सो आई फाउंड अ न्यू जजमेंट, आई कैन प्रीटी वेल मेंशन अ न्यू जजमेंट. आई एम नॉट मेंशनिंग अ न्यू पॉइंट बिकॉज द पॉइंट इज ऑलरेडी मेंशन्ड इन मेमोरियल. देन दैट्स अ बोनस पॉइंट फॉर यू कि आपने अपने आर्ग्यूमेंट्स को इतना ब्रॉडर पर्सपेक्टिव से लिखा कि कल को आपको कोई और मेजर जजमेंट भी मिली, यू ऑलरेडी हैव द प्लीडिंग्स इन इट in the memorial. So arguments advanced, there's also a way of writing the arguments advanced. The first point being that कि आपको अपने arguments advanced को directly नहीं शुरू कर देना है. अर्थात अगर आपकी कोई एकदम important judgment है and it is the judgment which is the landmark judgment given by a 7-judge bench, you would not want to mention that judgment in the very first paragraph because then you're not laying down a proper foundation for your arguments. It is obviously in my suggestion that you can start laying down the foundation by first introducing your facts कि इस issue के favor में आपके क्या facts of the case है. Obviously I have not drafted it in detail in the present memorial because I wanted to discuss it with you guys first. तो अगर मैं इस memorial को draft करते वक्त लिख रही होती, so first I would have written the facts of the case कि in the present case Techno Innovators through their directors is a company being run through their directors and they've been in this business for so and so years. Whereas the complainant, he had a financial transaction with them, and then Techno Innovators had issued the present check. The check was dishonored on so and so date, and as per section 138, they are liable to pay the double the check amount. तो यहाँ पे आपने इंट्रोडक्शन दे दिया फैक्ट्स के थ्रू. सो आपने 2 पैरास खत्म कर लिए. Then you can go on to write कि the check had been dishonored for XYZ reasons. Now, since they are a private limited company, as per section 141, the directors are liable to pay the complainant. आपका third para खत्म हो गया. So now, after your 3 paras are done, you have to now start laying foundation for the judgments which you want to say. So अर्थात अगर आपका कोई judgment है which says that under section 138 the presumption lies in the favor of the complainant, तो अभी आप judgment कैसे cite करेंगे? हर जजमेंट के बॉडी में कोर्ट की रूलिंग होती है about what the honorable court has ruled in favor of the complainant or in favor of the respondent. So us ruling ko, it is in my suggestion, you can frame it and use it in your arguments. Like for example, if the honorable Supreme Court had said that the complainant, if he has proven the ingredients of section 138, then in such a case presumption lies in favor of the complainant, and then the accused has the burden to relay its liability. So in such a scenario, आपने ये जो सेंटेंस है ऑनरेबल सुप्रीम कोर्ट का, इसकी आर्ग्यूमेंट बना के अपने मेमोरियल में डाल लिया. सो यू कैन रीड अ पैरा आउट ऑफ इट, एंड देन यू कैन वेरी वेल साइट द जजमेंट यूजिंग अ वे व्हिच आई विल बी शोइंग राइट नाउ. लाइक फॉर एग्जांपल, यहाँ पे लास्ट सेंटेंस है डेलीगेशन ऑफ अथॉरिटी cannot absolve their liability under law. Now in support of this, if for example I'm citing this judgment SMS Pharmaceuticals versus Neeta Bhalla and others. So what I'll do is, there's a very clever way and you get marks for this. I'm going to go to the insert section of Word document. Sorry, not insert. I'll be going to the reference section of the Word document, and I'll be going to insert citation. So यहाँ पे, sorry, insert footnote. When you go and insert a footnote, you'll be able to mention the source of this information जो आप कह रहे हैं. So instead of writing the judgment इस तरीके से in the paragraph, it is always welcomed in the competitions where you add a footnote and mention the judgment, and you always get marks for this. So जब जब आप आगे बढ़ेंगे अपने paragraphs में and you write anything else and you then add a footnote, तो वो अपने आप numbering करता रहेगा. These footnotes act as a brownie point to your memorial marking, as well as it looks neat. इनफैक्ट आप यहाँ पे अपने प्रोविजंस भी मेंशन कर सकते हैं, जैसे कि इफ यू आर राइटिंग दिस बाय साइटिंग सेक्शन 138 ऑफ द एनआई एक्ट, सो यू कैन वेरी वेल मेंशन दैट एज वेल. This is the way you have to go around with writing the arguments advanced. And a more important part about this is that you have to also acknowledge the fact कि आपके against भी कुछ judgments होने वाली हैं. So in my view, what I used to do is that I used to go through the judgments which are against me, so that I'm very well prepared कि अगर during the arguments the respondent cites these judgments, I have an answer to them. And in fact, I'll tell you one more interesting thing. Every judgment which is in favor of the respondent has some or the other sentence which even the complainant can use, and every judgment which the complainant cites has one or the other sentence जो respondent use कर सकता है. So it will be a very fun thing अगर आप कोई ऐसी judgment लिख रहे हैं, cite कर रहे हैं जो respondent ने भी अपने memorial में cite कर रखी है, and then the judge says that how come you both are relying on the same judgment, and that's when it can become a very big debate point and you can argue your case even well कि this judgment sir जो respondent को लग रहा है कि उसके favor में है, it has mentioning of a very peculiar point जो complainant के favor में आता है. So hence in such a scenario the present honorable court has to give a new ruling on it, and the new ruling in my case based on the facts has to be in my favor. This way you are breaking their judgments and you are making a good point for your case. And then to the very important part, जब आप अपनी आर्ग्यूमेंट्स एडवांस्ड को कंक्लूड कर रहे हैं, आपका कंक्लूजन एक समरी के साथ आना चाहिए कि आपने जो ऊपर के 10 पैराग्राफ्स लिखे हैं आर्ग्यूमेंट्स एडवांस्ड के अंडर, उन सब में आप क्या कह रहे थे. Because end of the day, after reading 10 paragraphs or 12 paragraphs, it is not possible for us to remember all the points. So एक summary जब आप दे देंगे in the 11th paragraph, you will give a gist of everything that I've already said, and you'll also refresh their minds. And as well as it is my humble suggestion कि आप जब issue 2 आगे शुरू करना शुरू करेंगे तो आप issue 1 का भी reference दे पाएंगे उसमें, that as stated above in the summary this was the case. Now going in pursuance of that, if section 138 is already attracted, section 141 also comes into picture. इस तरीके से यू आर गोइंग स्टेप बाय स्टेप. None of your issues are excluded of each other. They are all inclusive of each other, which also looks good to hear also when you argue. Now, once your arguments advanced are done, we come to the prayer. Now, for all my fellow participants, you may take a screenshot of the prayer because drafting of the prayer is also quite a peculiar issue with law students. कि लिखना क्या है? So, our prayer has to state one simple sentence every time that, in light of the facts stated, arguments raised, contention mentioned, and judgment cited, the petitioner seeks the following relief from the Honorable Court. And accordingly prays that the Honorable Court be pleased enough to. अभी टू के आगे आपको क्या मांगना है, इट इज बेस्ड ऑन द फैक्ट्स ऑफ योर केस. अभी हमारे प्रेजेंट केस में सेक्शन 138 को अगर हम देखें तो 138 में वी ऑलवेज हैव अ रिलीफ टू गेट डबल द चेक अमाउंट. Now, as a petitioner, if you do not read section 138 and you do not mention the prayer that you want double the check amount, it is negative marking for you because you did not ask what is most crucial. इसी तरह there are a number of provisions which have specific reliefs given under the law. So you have to ensure कि आपके केस को कौन सा प्रोविजन लग रहा है एंड उस केस को उस प्रोविजन के अंतर्गत रखते हुए क्या रिलीफ आना चाहिए. यू आर मेंशनिंग द प्रॉपर रिलीफ इन योर केस. अदरवाइज द जज इज गोइंग टू गिव यू राइट लेफ्ट एंड सेंटर कि आपने गलत रिलीफ मांगा इस कोर्ट से, आई कैन नॉट एंटरटेन द प्रेजेंट पिटिशन. So ensure you write the correct relief, and obviously the last sentence is always common. Any further order in the favor of the complainant in the interest of justice, equity, and good conscience. And that's when you end your prayer with, for this act of kindness, the complainant shall be duty bound to forever pray. And the last part is an addition which I made to my memorials, the date, place, and sign based on what we actually use in the present courts. So here I give you a gist of how memorials are drafted. And now I believe I should come to a little discussion about the mood problem because I believe हम सब ने ही पढ़ा होगा mood problem. It was quite an interesting one कि जब सबके सब डायरेक्टर्स ने हाथ खड़े कर दिए कंपनी के तो 138 का प्रोविजन अट्रैक्ट होगा या नहीं. So if any of the participants have any view in regards to the mood problem, they may send it to me and I'll always be discussing them. If not, then I'll directly be proceeding with the discussion of the mood problem. So I believe we don't have any questions as of now. Okay, for the sake of discussion. Whether the dishonor of check issued by Techno Innovations Private Limited constitutes an offense under Section 138 of Negotiable Instruments Act. अभी हमारे केस में टेक्नो इनोवेटर्स ने चेक तो दे दिया, but when the case came for trial, Techno Innovators has said कि उनके directors have said that we don't know about the transaction. So in such a case, the question comes into picture कि जो debt आया है, क्या वो debt legal भी है या नहीं? So if I have to talk as the complainant can always say that as a complainant, I have to only prove the ingredients of Section 138. Now, what are the ingredients of Section 138? Ingredients are as simple as the very fact that there is a legal debt, then a check was issued in view of the legal debt, the check was dishonored, a demand notice was sent, the demand even after receiving the demand notice, within 15 days no payment was made, and hence there is the cause of action for filing of the present case. If all these 5 things are satisfied, we have satisfied the ingredients of Section 138 and presumption comes in the favor of the complainant. So अगर हम complainant की ओर से argue कर रहे हैं, we have satisfied all the 5 ingredients. They are there before the honorable court, and hence offense under Section 138 is proven. But if I have to talk as the accused, I can always say that the debt was not a legal debt. Reason being, the company had no idea about this transaction because company is end of the day not an actual person, it is a legal person. तो कंपनी को जो चला रहे हैं, they are the ones who are in knowledge of the transaction. If they are themselves not in knowledge of the transaction, that means it's a bogus transaction. अगर ये transaction ही bogus है, that means the debt is not a legal debt. Hence, Section 138 is not attractive. So this way, we can argue from both the ends. Then coming to the second issue, whether the directors, specifically Mr. Rakesh Kumar, Priya Sharma, and Sanjay Verma, are criminally liable under Section 141 of the NI Act despite their claims of delegation of responsibility. तो इस केस में there are 2 views. First view under Section 141 है from the side of the complainant कि कोई भी कंपनी का रिस्पॉन्सिबल जो पोस्ट होती है जैसे मैनेजिंग डायरेक्टर, होल टाइम डायरेक्टर, सीईओ, they are responsible by default for the affairs of the company. So they cannot run away from their liabilities. Hence, as a complainant, I have to say that liability is inflicted under Section 141. But if I'm from the ends of the accused, so there's a judgment of Honorable Supreme Court, which says that if the directors are not in charge for day-to-day affairs of the company, they are not liable under Section 138. And as the facts of the case say, the directors mentioned therein have pleaded that we are not in charge for day-to-day affairs. So they can very well argue that as per the Honorable Supreme Court judgment, we are not liable in the present case. The in fact, complainant has to prove that I am in charge of the daily affairs of the companies. Now, moving on to issue C, whether the defense of delegation of authority and lack of knowledge is a valid defense under Section 141 of the Negotiable Instrument Act for the individual directors. The point is that individual directors are those directors who are specifically mentioned in the company records that they are not managing the daily affairs of the company. So in such a scenario, Section 141 attract होगा या नहीं? Now obviously our moot problem is not talking about actual facts of the case, जहाँ पे हम ये देख पाएं कि if these guys are actually handling any transaction or not. But if the moot problem had been more specific, as in a moot court, तो हम always argue कर सकते हैं कि जो directors हैं, they have been talking to the complainant company, they have been conducting the transaction with the complainant company. So hence they cannot shy away from their liability under Section 141. And then lastly, what is the scope of vicarious liability of directors under Section 141 of Negotiable Instrument Act? So there are n number of judgments in regards to this on both the ends, complainant as well as of the accused, which state the respective arguments. For the complainant, it states that they are vicariously liable because end of the day, 141 specifically states that as soon as Section 138 is attracted for private companies, their position holders have to be pleaded in the case and held guilty. So this is where we put a rest to our memorial drafting. And any doubts, if anyone?
Thank you so much, Vaishali. Participants, please feel free to ask your queries. आप आपकी queries हिंदी में भी पूछ सकते हैं. Feel comfortable. Let it be any, be it a basic query. Please feel free to ask. It also lets the speaker know that you all understood the session. It's a form of a feedback to the speaker. Please do ask queries if possible.
Yeah, hi Vaishali. First of all, congratulations. I heard you for the first time, and I am a first year law student. And the kind of confidence that you have shown and the way you are presenting, it is very inspiring. You are young, enthusiastic, and a long way to go. But being in the middle age, I could able to see the spark in you, and I'm looking forward to be like you, the way you have presented it. Okay, it is outstanding, and yeah, it is my first session, so I couldn't able to understand much, but the way you have explained it, it is very systematic. I would say that, and your presentation is absolutely fantastic. Congratulations for that.
Thank you so much, Smita ji. Good to hear.
So, two common queries are how to research case laws with the help of artificial intelligence.
Okay. Never research case laws using AI. Because जब चैट जीपीटी नया नया आया था, I tried doing it, and when I realized, obviously suggests judgments, but when you check those judgments online through SEC or Manupatra, you realize कि वो judgments exist ही नहीं करते. It has happened with me. That's why I'm suggesting that many a time AI hallucinates. Sometimes it may give you the actual results, but many a times it hallucinates and gives you judgments which do not exist. So it is a very risky affair to try AI for judgments. I would rather suggest कि आप Google कर लीजिए. You'll get actual judgments over there.
Okay. The next question is any tips to analyze a moot court problem?
That's a good question. So, moot problem, as I said, the drafters of moot problem, I believe, they don't like law students a lot because they make moot problems going for 20 pages and then they expect law students to understand four issues from the 20 pages. So honestly, उनका purpose यही होता है to confuse you to such an extent जहाँ पे आप यही समझ नहीं पाते कि इन issues को answer करने के लिए मैं इस moot problem का इस्तेमाल कैसे करूँ. So that's where you have to actually look at the issues first कि आपको argue क्या करना है, and then you have to figure out कि वो issue के related facts कहाँ कहाँ है, and you have to focus on those facts only. If to support those arguments you see that there are facts ahead of it, then only cite those facts. Otherwise, I understand mood problem वो जानबूझ के ऐसी बनाते हैं that they are able to confuse you a lot. And always give little attention to the details. कई बार वो जो dates होती हैं, time होता है, हमें लगता है that it is not necessary, but I always prefer making a chart to see the flow of the case, as in पहले क्या हुआ, उसके बाद क्या हुआ, and then you find some peculiarities in the flow of the case. You can argue on that also.
Okay. One more question in from the registration form only that I'm taking. Um, any tips for presenting the mood problem? Your it's written mood problem, but I guess it is your argument.
हाँ. So for presentation, first important point, you have to be thorough with your arguments. आपको आपकी जुबान पे होना चाहिए आपके सारे पॉइंट्स, बिकॉज एज आई सेड, जब आपको 20 पॉइंट 10 मिनट में बोलने पड़ते हैं, स्पेशली विद द जज सिटिंग इन फ्रंट ऑफ यू, यू हैव टू स्क्रूटनाइज हिज फेस एंड देन रियलाइज कि उस टाइम पे वो कितना सुनने की क्षमता रखते हैं. आई अंडरस्टैंड, बिकॉज जो प्रिलिमिनरी राउंड्स होते हैं मूड कोर्ट्स के, दे हैव टू हियर 10 आर्ग्यूमेंट्स इन अ डे. सो यू हैव टू बी सो स्मार्ट कि आप उस टाइम पे उतना ही बोल रहे हैं एंड वही बोल रहे हैं जितना जरूरी है. सो ऑब्वियसली द ट्रिक फॉर दिस इज दैट आपके जो मेजर पॉइंट्स हैं, मेजर एज इन लैंडमार्क जजमेंट्स अगर आप साइड कर रहे हैं, या फिर कोई ऐसा प्रोविजन आप साइड कर रहे हैं जस्ट गोइंग टू हिट द रिलीफ विच यू वांट, mention those provisions first, and then if the judge wants that yes you argue more, then you proceed with your Ram Kahani Puri.
Any limitation on the number of case laws that we should cite in the memorials?
Not at all. In fact, once I had seen a guy carry 500 pages ka compendium. So I can expect at least 50 judgments in there. So there's no constraint on that. Go trouble the judges with as many judgments you want.
Okay. Then Vaishali, registration form say etiquettes per question hai. Can I take, because last time you had discussed, so I think it will lead to repetition, right? So we can
Still, I
skip
believe
this,
new
right?
participants might be there, na? So as one ma'am just mentioned that she is hearing it for the first
Yeah,
time.
first one.
हाँ. सो एटिकेट्स, सो आपके
Yes.
एटिकेट्स में सबसे पहले आपका अपेयरेंस आता है. आप मूड कोर्ट में जब भी पार्टिसिपेट कर रहे हैं, यू हैव टू एंश्योर यू आर वेयरिंग अ प्लेन वाइट शर्ट, नो चेक्स, नो स्ट्राइप्स, नो पैटर्न्स, प्लेन वाइट शर्ट विद अ कॉलर एज वेल एज अ ब्लैक टाई विद इट. टाई के ब्राउनी पॉइंट्स होते हैं, दैट्स व्हाई आई एम सजेस्टिंग अ ब्लैक पैंट, अ ब्लैक ब्लेजर. पीपल वेयर डार्क ब्लू ब्लेजर्स, इट रिफ्लेक्ट्स द लाइट एंड आपको दिखता है कि वो ब्लू है. प्लीज डोंट वेयर दोज. And then you have to wear formal black shoes. I'm saying this for the women because men usually wear black shoes, but women, they wear all sorts of shoes. They wear anything starting from pink till green. So wear proper black shoes. And when you're standing before the bench, I won't call them the court, but when you're standing before the bench, you have to address them with heavy words. Why I'm using heavy words? Because you don't use these words in courts nowadays. You say sir and ma'am, but over there you have to say that with the permission of the honorable bench, if I may approach the dais, then you're going to approach the dais. फिर आप डाइस पे खड़े हो जाएंगे, then I'm going to say that with the permission of the honorable bench, if I may read out the facts of the case. So ऐसे करके आपको वो शब्दों का इस्तेमाल करना है जो आपके जज को अपीजिंग लगे, एंड देन यू हैव टू टेक परमिशन फॉर एवरीथिंग. अर्थात फैक्ट्स बोलने हैं, आपको परमिशन लेना है. आपको आपका फर्स्ट इशू बोलना है, आपको परमिशन लेना है. फिर उसके बाद आपको आपके अगर कोई जजमेंट साइड करनी है, आई डू दैट विद द परमिशन ऑफ द ऑनरेबल कोर्ट इफ आई मे प्रेजेंट दिस जजमेंट. सो उससे क्या होता है ना, दे कीप वेकिंग अप इन द मिडिल. अगर हम मोनोटोनसली बोलते जाते हैं तो वो सो जाएंगे बीच में. सो कीप आस्किंग देम that sir, I would like to draw your attention to this very interesting point. So this way they are hooked up, they have to listen to you because you're looking them in the eye and saying that listen to me.
Okay, Vaishali. There is one more question in the registration form. Um, 1 second. When to put an end to research and start drafting? Because at times the research is never ending.
एकदम सही कहा है जिस बच्चे ने भी कहा है, बिकॉज many a times research करते करते if we don't stop at the right time, we may end up confusing ourselves and हम कुछ draft ही नहीं कर पाएंगे. So what I do is I usually take a time barrier, like if I've researched for 10 hours, after that I start drafting. भले मेरी research अधूरी है, I've not reached a conclusion, but at least if I start drafting my points, clear हो जाता है मेरा story line. And I also stress upon the key points, key words of the case, because जब हम drafting करते हैं ना, कोई एक word repetitive आ जाता है. And then drafting करने के middle में you realize that yes, this word is quite crucial to the case, and you research on that word and you find up appropriate judgment. This happens with me usually, so that's why I'm sharing that. आप एक time constraint रखिए, कि इतने घंटे रिसर्च करने के बाद आई एम गोना स्टार्ट विद द ड्राफ्टिंग.
Okay, Vaishali. So done with the queries from the registration form.
Just one doubt, Malvika ji.
Acha,
Kiran
what is
Motiani
one?
has messaged that
Okay,
what
okay.
are
I
hand
didn't see that.
gestures
Okay, sorry.
that we have to follow. So Kiran ji, hand gestures. Uh, अगर मैं specifically बोलना चाहूँगी, then you can be quite expressive with your hands. I love to do it when I'm talking, but there are few hand gestures which I have seen students do, and I didn't like them honestly. One was the pointing finger one, where the participant was pointing his finger to the judge and saying that this is not right. So I feel that is quite offensive to the bench. They might not take it in a good way, and it's quite offensive. So please never point fingers. Secondly, I believe fiddling with anything, like if you're fiddling with your tie or with your button, that is not a good impression. It shows underconfidence to the judges. And obviously, not with your hair. For women, especially who love to keep their hairs in the side and bar bar karna, it doesn't look good. So always keep your hands to yourself. If not to yourself, then be a little expressive with them, not too much expressive.
Oh, that was a good question.
So I believe questions are done, Malvika ji.
Yeah, Vaishali. So with this, we conclude the two-part series of Moot Court. So thank you so much. There's one question. Can
Yes, questions are now coming up.
yeah,
Participants,
I know what are the participants doing. Wait, I'll just.
one is there of Aksa Zakar, where a mood problem is of 2-3 pages. How to write statement of facts? Like in how many pages? ओके सो अक्सा जी, सबसे एक इंटरेस्टिंग ट्रिक इसकी ये होती है, आप टेबल बना सकते हैं. तो टेबल, अगर आपकी इच्छा है कि आपको स्टेटमेंट ऑफ फैक्ट्स 2-3 पेज तक रखना है, उससे लंबा करना है, तो एक टेबल बनाने से आपके स्टेटमेंट ऑफ फैक्ट्स लंबे भी हो जाएंगे एंड आप उनको थोड़ा नीट वे में प्रेजेंट कर पाएंगे. अदरवाइज देयर इज नो प्रॉपर फॉर्मूला कि आपको कितने पेजेस का ही रखना है. इवन इफ इट्स ऑफ 1 पेज एंड इट्स कंसाइज, इट्स परफेक्ट. एंड आई
Okay,
थिंक
participants, any more queries or we can end? The Vaishali, can I end?
यस, आई बिलीव वी आर डन विद द क्वेश्चंस.
Okay, so sorry about this. So thank you so much, Vaishali, for firstly taking out the time to prepare the mood problem. It takes a lot of preparation. So thank you so much for doing this and giving us so much clarity on the subject. I'm sure the students also got to learn a lot. And also when we upload this on YouTube, the viewers too will benefit from the two-part series. Thank you so much, Vaishali.
थैंक यू.